So for her to see how they use cooperators to drive up weight, even at sentencing, even after a plea bargain, there would be this weight added on, and the sentences would get extremely long. So here she talks about somebody getting caught with a $20 rock of crack cocaine, and all of a sudden they're getting sentenced on 300 grams or something like that on crack cocaine. And I saw this in court. I saw one person who was caught with 8 grams of crack cocaine, but through relevant conduct, the judge sentenced on close to 1,500 grams of crack cocaine. The person also was, when they busted him, they went into his house, they found a gun in the house, so he got an extra 5 years for the 924C, and ended up getting a sentence of more than 20 years in that case. And then I'm going to wrap up quickly here. My time's running out. In this case from the Southeast District as well, I'm really kind of focusing on how bad it was there. This shows how even when there's a plea bargain made between a prosecutor and a defense attorney, and they kind of agree to what the relevant conduct's going to look like, and they're kind of agreeing to what those terms are likely to look like at sentencing, the prosecutors can do, kind of end up giving information to the probation office beyond what's in what's called the statement of facts, that's supposed to lay out the things that the probation office would calculate in terms of relevant conduct. And they would, calculate that, all the stuff that they can find in the file. And in this district, there was also in one of the divisions in this district, the probation office would routinely call up case agents to try to see if the prosecutor was hiding information from them so that they could add to relevant conduct. And the judge and several of the judges in this district would take all of that relevant conduct and apply it, and then stick to the guidelines or be very close to the guidelines in terms of sentencing. So with that sort of depressing ending, I'm going to just turn it over to our next panelist. Thank you.
All right. Here, in fact, with Katie Tino at Irvine, and also Erica Zuppel at Chicago, where our clinic students are going to be taking some of those cases for clemency. We've got a couple questions up already, but I'm going to hold off on those, and we'll circle back to them after all the panelists have spoken, because other people may have something to say on these issues. And I'd remind people too that if you have a question, there's a Q&A button down at the bottom. Just hit that and type in the question, and we'll circle back at the end. And now we're going to hear from Judge Gertner.
I have a very odd presentation. And I have an odd presentation because it follows along with what Mona has done, because I wanted to talk personally about what it was like to be a judge in dealing with these issues. I'm writing a book about the men I sentenced, what it was like to be the judge in the position that Mona describes, for example. And I've met some of them afterwards. It's called Incomplete Sentences. And the reason I'm writing about it is, even though the federal sentencing guidelines are advisory, I am persuaded that what I've begun to call the habits of mass incarceration die hard. And when you are beginning to look at people in the way we've come to look at people, it's very difficult to unlook at them. So I'm going to describe a sentencing first, and then I want to take the points that we could glean from that sentencing, rather than, and this is an actual case that I've written about. It's the case of Damian Perry. He had no adult record. He was found with a small amount of crack, but he was part of a 30-person gang sweep. And under the guidelines, he would have been facing perhaps 5 years. Here's his background. His mother was 17 years old when she had him. She had descended into addiction and prosecution. And then his father was 15. By the time Damian was 3, his mother's substance abuse had progressed so far she was unable to care for him. He didn't see her again until he was 8, when he visited her for a weekend. She went to jail. He never saw her again. He had no contact with his father at all until much later in life. The The addiction that had surrounded him on his mother's side and the fractured family led essentially to his own serious drug problem. He began smoking marijuana at 13, soon progressing to daily use, 13 beginning with marijuana. By 17, he was lacing the marijuana with crack. By 20, he was using substantial amounts of both. When he dropped out of school, he needed to deal drugs in order to support himself. Crack had hit Boston hard in 1988, replacing heroin. The street that he lived on was one of the first to have crack. And then there was violence. As Bruce Western writes, in poor families, people do not specialize in either victims, offenders, or witnesses. One inhabits all of these roles. Damien's case was the most extraordinary. At 16, he was shot in the head. Accidentally, the newspaper said, but it wasn't clear from the facts. He lost his left eye and was hospitalized. The doctors could not remove pieces of the bullet because they were too close to a major artery. The fragments remained in his head, causing him headaches so severe he could not speak. He had hearing loss, blood clots, seizures. He had already suffered from depression because of his mother's abandonment, but after it got worse, exacerbated by post-traumatic stress disorder. His life changed. He was now a teenager with needs far too complex for his mother to accommodate. He skipped school, he dropped out, he started to deal drugs. The school that he went to was a school that had lost its accreditation. It didn't take much to drop out of it. And the psychologist reported that he was depressed, substance abuse, physical and emotional trauma, that he seemed to be impossibly compressed, he said, into 21 short years. Notwithstanding all of that, he had no adult record. Nothing that I had learned about Damien mattered. There was no box in the sentencing guideline for his abandonment, none for his depression, none for his drug addiction. There was no score for the unbelievable trauma of having been shot. I wasn't supposed to try to understand how likely it was that a long prison term would make his problems worse. All I was supposed to do, as Mona described, was to robotically total the drug amount he sold, figure out his criminal record, situate him on the sentencing grid, and pick a number. Let me say again, he had no adult record. He had never been in prison, let alone federal prison. I wanted to give him probation. This is 2005. I wanted to give him probation, but I knew that if I did, this is before Booker rather, that if I did, I'd be reversed, no matter how well I explained it. His lawyer argued for extraordinary physical condition departure. In the opinion I wrote on this, I said, Damien Perry has a bullet in his brain. Whether that's an extraordinary physical circumstance enough to warrant a downward departure, to ask the question is to answer it. Prosecutor wanted 14 years. Let me say that again. The prosecutor wanted 14 years. 14 years is what we'd use for transmitting, is a sentence for transmitting national defense information, assault with intent to murder, criminal sex abuse, kidnapping, an abduction. If that's what the guidelines require, I thought to myself, then as Oliver Twist, Mr. Bumble said, the law is an ass. How could one possibly justify that? There was a cooperating witness who would say anything to get out of a much longer sentence than what Damien was facing. He was 11 years older than Damien with a very long record. He had dealt in substantial drug quantities. His potential sentence was over 20 years. He was the one who testified that, oh yes, notwithstanding the fact that he was largely addicted himself, he managed to recall seeing Damien at specific times with specific quantities amounting to more than 50 grams. And that would get to the sentencing range the government wanted. Worse, there was then another cooperator also facing more time than Damien should have been facing, who said that he'd seen Damien shoot into a crowd. He'd seen it. This wasn't charged. There was no proof. It was one cooperator at a sentencing proceeding in which there were the evidentiary rules are loosened, telling me he had seen Damien shoot someone in a crowd. And then there was a pending gun charge, a pending gun charge that I was supposed to take into account. The entire exercise I wrote in my notes was absurd. Sure, drug quantity may be a proxy for the question how big a dealer was Damien, but why should that matter to the sentence? Where did Damien live? With his grandmother. How did he live? A marginal existence. Where was he on the rung of dealers and suppliers? This guy who sold small quantities on street corners, who met buyers in a beat up bicycle. Did the accumulation of small sales on a street corner really show that he deserved the sentence the government sought? Sentences that I thought were reserved for drug dealers, drug managers and dealers. It got worse. That bullet in his brain, Damien insisted was really no big deal. No big deal. The government said essentially, after all, he had managed to deal drugs, notwithstanding that bullet in his brain. It was a version of, he did the crime, now you should do the time. He engaged in risky behaviors. I thought to myself that if this had been a white middle-class defendant, I would have gotten elaborate stories about post-traumatic stress disorder. We would have been appalled at the stories we were hearing. We would have responded accordingly, guidelines or no guidelines. The prosecutor would have responded accordingly. I sentenced Damien to 4 years. I gave him a 1-year departure from the guidelines as I had calculated him. For someone who had never been in prison, let alone a federal one, this was a substantial sentence. Before the guidelines, a 5-year sentence was huge. 20 years later, it was a gift. What do we learn from this? What do I learn from this sentencing? This is one of the 6 or 7 stories that I tell in my book. First of all, the guidelines privileged one factor, drug quantity, to the exclusion of virtually all others. You can't consider addiction is not ordinarily relevant. Mental health issues are not ordinarily relevant. Adverse childhood experiences are not ever relevant. You ignore all of the issues that prior to the guidelines would have in fact driven a sentence and should have driven a sentence. If I had gone on about those factors in his background, I have no doubt I would have been reversed. We privileged one factor, drug quantity, over all others. And why was that? Because the federal sentencing guidelines wanted to eliminate, not an illegitimate concern, wanted to eliminate disparity. And it was easier to pick a quantity that was objective rather than addiction, mental health, adverse childhood experiences, which were arguably would have introduced judgment into this setting, which would have meant my judgment would have been different than the judge in the courtroom next to me. Of course, we now know, I've spoken in other programs, I teach with the Federal Judicial Center and with the Center for Law, Brain, and Behavior about what we now know about mental health issues and drug addiction and the impact of trauma. We're not guessing about that. I am not simply being a knee-jerk Northern liberal when I talk about those issues. They are grounded in science, and we can sentence on the basis of them. We privilege disparity more than we privilege fairness, than we privileged proportionality, more than we privileged rehabilitation. We disconnected sentencing completely from rehabilitation. Damien's case was a classic case. We could have intervened at that moment in his life. There were things to have been done. He was only 21. The sentencing guidelines have enabled prosecutorial manipulation. Damien's lawyer had no idea when he was initially charged who in that group of 30 would rush to the courthouse steps first to cooperate. And of course, the ones who were the most vulnerable, the ones who were facing the most time, cooperated first, talking about quantity, talking about violence, etc. We've enabled uncharged conduct. Damien's case suggests I was supposed to increase his sentence because of a pending gun charge. And worse, we've enabled acquitted conduct. That is to say, if he had gone to trial and had been acquitted of whatever the quantity was, I was still supposed to take that into account in my sentence. I believe that drug sentencing has distorted advocacy, judging, prosecutors, even probation officers. It certainly distorted advocacy. When the guidelines became, became advisory, lawyers were still stuck then, as they are now, in talking not about the full human being in front of them, but talking about drug quantity, because they're obliged to calculate the drug quantity first under the guidelines before they can get to anything else. It has distorted the plea process, again, as Mona described, because whereas it always had been the case that when someone went to trial, there was a risk that their sentence would be higher if they went to trial, because you'd learn more at trial. Nevertheless, with the guidelines, there was a one-to-one correlation between any additional quantity that you learned of at trial, and the sentence you were obliged to give. And in that universe, where there's a one-to-one correlation between evidence of drug quantity and the sentence, even post-Booker, it privileges pleading guilty immediately to control the information that the judge gets. It's distorted advocacy, it's distorted trials. In my view, it's also distorted judging. Guidelines, advisory or not, make it easy to judge people by formula. Make it easier and quicker to dismiss people, to see the category and not the human being. And it certainly has distorted policing. The police in the Perry case knew exactly how long they had to wait on the corner to get to the quantity that would have triggered, in this case, not a mandatory minimum, but mandatory guidelines. I think it's critical that we look at this because it hasn't changed materially, although the guidelines have become advisory. I think it's critical that we go back to understanding what motivates people to engage in drug dealing, where they are on the pecking order, the difference between major dealers and minor dealers. And although that will introduce disparity into the system, information and training and peer review and analyses can address that. In any event, in this world, candidly, I would choose fairness over disparity any day. Thank you.
And thank you, Judge Gertner. As usual, you got right to the heart of what matters here, and that's essential. And next, we're going to turn to Oren Gur for the perspective from Philadelphia.
Good morning, everybody. Thank you very much for inviting me to present today. Super honored to be on a panel with such esteemed presenters. I'll be speaking about progressive prosecutorial discretion as we enter the matrix. And that is an allusion both to sentencing matrices and also the movie, and the idea that, there's lots of numbers involved in the matrix, and I'll be talking today about some of the data that we've been using in Philadelphia and some of the policies that we've brought about that I think, in my mind, mitigate some of the potential harms of sentencing criteria. So before I get started, I'll say my views don't necessarily represent those of the Philadelphia District Attorney's Office. This is my attempt to synthesize some of our efforts to date. So I'll be touching on progressive prosecutorial discretion more broadly, and then talk about less charging and bail and more diversion as strategies to mitigate those sentencing criteria. Plea offers and better plea offers are another example. And then finally, I'll touch on the relevance of information technology and data to some cases, Brady and Wardlow. So progressive prosecutorial discretion can be characterized by the increase in the past decade or more of prosecutors who have a different perspective and a different approach to engaging with the criminal legal system. So from left to right, you'll see State Attorney Marilyn Mosby to DA Krasner in the middle, and this is in the order that they came to be elected. These are just a few examples of progressive prosecutors as broadly defined. And at this point, progressive prosecutors account for roughly 20% of the population, or they have been elected in jurisdictions that represent 20% of the US population. So discretion is not new, right? It's not new in prosecution. It's not new in the criminal legal system. This is an article from the Yale Law Journal in 1960 that shows that there are these areas of no enforcement, right? You have substantive laws of crime, lots of areas of total enforcement. And as you go through the process, there are decisions not to enforce. And these are discretionary decisions that have been part and parcel of our system for a long time and are not new. And I think progressive prosecutors are wielding them a little bit differently than they have historically, with important implications for drug law. Now we'll get into less charging and bail and more diversion. So this shows the decrease in drug cases charged per month in Philadelphia. You can see in very light blue, right around here, 2018 is when DA Krasner came into office. Shortly thereafter, in February 2018, there was a policy memo released that included instructions to decline certain charges, such as possession of cannabis regardless of weight. Now, if you cover, the right side of this graph, you'll see that the decline hasn't been that great. It looks very steep because of COVID and efforts to reduce the number of people going into jails during COVID. But overall, the number of cases charged, drug cases charged, year-end counts, has stayed in, over 10,000 year to year in Philadelphia. So in spite of these efforts to decline certain charges and to do less charging, there are still drug cases charged in Philadelphia. This is a graphic from a paper by Orly Oos and Megan Stevenson, who evaluated our 2018 bail policy. And what it shows here is cases per week for these three different charges. Marijuana is clearly drugs, but these others are often associated with drug use. And what you see by this line drawn here is that relative to the policy memo that I referenced before, this February 2018 policy memo, there are many fewer cases being charged per week for all three of these. And you see a clear cutoff, a regression discontinuity. And then in January 2020 and January 2021, we also decriminalized possession of buprenorphine and fentanyl test strips as an attempt to, do less charging of substance use and harm reduction related material. So part of charging is bail and what our office requests and seeks for bail. This graphic here is an analysis of 5 years of data in Philadelphia, over 200,000 lead charges. In blue, you see the proportion of cases where bail was not requested or bail was not set at a monetary amount. So people would get ROR, released on their own recognizance. In orange, you see bail set less than $10,000. People would have to pay 10% of that to get out. Not everybody can do that. So there are clear racial disparities. And then in gray here, you see bail being set at more than $10,000. The stars here help see some of the drug-related charges. And basically the goal of our bail was to take all these orange parts of the graph and make them blue, right? So our ADAs, our bail reps, would not say anything in terms of what bail should be set at in these particular charges. And again, using outcomes from the previous 5 years, this is how magistrates were setting bail already. We could argue that if you're willing to set bail at such a low level, you might as well set it to release on your own recognizance or sign on bond, because setting bail at such low levels will have disparities. And that policy affected over 2/3 of charges and was effective. This is an example of the change in release on recognizance rates, and arrows going up show an increase in release on recognizance rates and blue going down. And this just shows that already in 2018, you see increases in release on recognizance rates for some of these drug-related charges. An exception would be possession of marijuana. Remember that the policy change there involved not charging smaller amounts. So that suggests that the balance of cases here would be more serious and larger quantities. So another way to reduce the impact of sentencing criteria is by doing more diversion. First, in February 2019, we put out a policy to expand accelerated misdemeanor program by removing barriers for entry. So people who had been in the program before, for example, could get other opportunities. Then in fall 2019, there was a more significant policy where we're dropping possession charges at first listing with proof of effort to connect to treatment. So if somebody is able to provide through their attorney proof of treatment, their case can be dropped at that very first listing. And here you see a graphic in the appeal that shows the proportion, the share of drug possession charges that have been dismissed or withdrawn by the Philadelphia DA's office over time. And I added this line to approximate fall 2019. So another really significant thing that you can do is give better plea offers. And these next few slides talk about policies we've put into place in an attempt to end what we call mass supervision. So this policy, there was a 2018 version, and then it was strengthened in 2019. The 2018 policy advised ADAs to seek shorter or no probation tails after a sentence of incarceration, and to seek shorter probationary sentences where no sentence of incarceration is sought. The 2019 policy gave more specific guidance. Counterfactuals were calculated to get a sense of what these particular numbers should be in order to achieve specific goals. So based on that, total supervision length should not exceed 36 months for felonies and 12 months for misdemeanors. And there was an office-wide average total supervision length established of 18 months or less for felonies and 6 months or less for misdemeanors. Here you see, after the 2018 policy and then after the 2019 policy, negotiated guilty pleas have become more common under DA Krasner. So the proportion of cases that are resolved through negotiated guilty pleas has increased, both after the first iteration of the policy and again after the second iteration. And I should note this is work done by colleague Tyler Tran in the Data Lab and others, and you can access it at this link down here. Following the reforms, median supervision length fell for most negotiated guilty pleas, but not for downgraded pleas. So drug sales and aggravated assault are the two most commonly downgraded felony offenses, and they tend to be downgraded to drug possession and simple misdemeanor assault, respectively. So, you know, in my mind, there are questions about the implications of those types of downgrades further down the road, for example, when it comes to those sentencing guidelines and how they're applied. And this shows pre-Krasner, post the 2018 policy, post 2019 policy, and what you can see is like a stepwise reduction in the median supervision lengths. This again shows similar information, but it does it on a week basis. So each of these dots represents a week, and you can see how right after the policies are implemented in 2018 and then 2019, you see felonies in orange, downgraded pleas in gray, and misdemeanors in blue get in line effectively, right? So these longer sentences now become in this middle range in the case of felonies. And then after the 2019 policy, all of these, the median gets lower again, right? And it concentrates around these goals. Importantly, we found that racial disparities in community supervision through negotiated guilty pleas have lessened under these policies. So previously, Black defendants' community supervision sentences were 10.8 months longer than white defendants on average. And then over time with these policies, the average disparity was reduced to 5.2 months in the case of Black defendants. So you get a sense, and this is something that, you know, we find really important and plan to incorporate into all of our future work, but really looking for these racial disparities to be reduced and tackling that on its head. This just highlights some specific drug statutes and how the change in median supervision length pre-Krasner and then post each of the policies, and then the change over time. So and again, this is in months. So pre-Krasner, it was 48 months of supervision for drug possession with intent to deliver. Post the 2019 policy, it's 24 for the median, and that's a reduction of 50%. So now I'm going to touch on Brady, Wardlow, information technology and data. So it's important to kind of explain at the Philadelphia District Attorney's Office, we're currently in the process of building a new case management system that will allow us to better do our work on the one hand, and also better have data for the work that is done. A lot of work in prosecutorial offices, this should come as no surprise to many, is done on paper. Ours is no exception, and we are trying to enter the digital age, and that creates all kinds of opportunities, right? So if you have a case management system, there are ways that information can be brought upstream, right? So similar to how some of these policies I've described have been upstream, things that can be done before sentencing guidelines are applied, you can also bring information using information technology so that it can inform ADA decision-making, discretionary decisions upstream. So I want to talk about briefly some ways that, one way we've been doing it, and then some other ways we've been thinking about that. So Brady versus Maryland, prosecutors constitutionally obligated to turn over evidence that is favorable to the accused, that is material to guilt or punishment. Failure to do so violates due process. Giglio, the court expanded that rule to include information that is relevant to the impeachment of witnesses. So with that in mind, our IT unit created a police misconduct disclosure database along with our conviction integrity unit. And what this does is at the time of charging, provides information to chargers in the charging unit of our office about prior misconduct, right? So they get an email, an automated email that's sent when an officer who's in the police misconduct disclosure database effectuates an arrest. They get an email outlining their prior misconduct, and that can inform their discretionary decision-making at the time of charging. That email is also sent at the time of subpoenaing. So ADAs throughout the office are aware when they subpoena an officer of anything that might be in that police misconduct disclosure database. Another idea comes out of Illinois v. Wardlow and writing by Andrew Ferguson and Damien Bernach. The idea that you can use a high crime area to evaluate the reasonableness of a Fourth Amendment stop. So effectively, there is no standard definition of what constitutes a high crime area. Data can be used to create such a definition or to inform an ADA's decision about whether a stop did indeed occur in a high crime area. So similar to the PMD, the Police Misconduct Disclosure Database, there's the potential to bring that kind of information to lift it up so that ADAs, when they're reviewing each decision, can also be informed by patterns and trends. So this is just kind of one example of how this type of information could be brought forward to ADAs and could be used to inform their decision making. This is an example of the racial composition of vehicle stops made by a particular officer. And you could use this to understand this officer's approach relative to others in their department, relative to others that work in their police service area, et cetera, et cetera. So furthermore, we know that there's legal discussions around how some of these issues come up, like the odor of cannabis in a stop and whether or not that can reasonably be used to effectuate a stop, and does it actually effectively uncover wrongdoing? Does it uncover illicit possession of narcotics? So here are some takeaways, some very broad takeaways. Policy changes in these areas that we've discussed can influence prosecutorial discretion in drug cases. You basically see that changing the policy did lead to changes in practice, did lead to changes in the graphics over time. Data allows for more specific policy guidance. You saw that with the ending mass supervision policy, and giving specific numbers led to additional changes and additional reductions. Similarly, bail reform increased the number of people who were released on their own recognizance. And then as just a good takeaway for the supervision reform, it reduced median length of supervision and associated racial disparities. It's really important to note, I didn't show data on this, but another takeaway should be that broad reform is possible without the sky falling. We did not see increases in pretrial recidivism or in recharge rates within 180 days for people in the supervision policy. We did not see increased failure to appear rates for defendants with the bail policy. So it's possible to make very broad changes without the sky falling. And I think that that just signifies that this is a great opportunity for reform. The last point has to do with progressive prosecutors and blue data. This is the last section that I spoke about with Brady, Wardlow, IT, and data. And what can you do with information that we have and that we generally use to keep track of defendants and people charged with crimes? How can that instead be used to inform decision-making and to increase accountability in the system? So just as a discussion, last points, the DA is one actor in the system. Sentencing guidelines are still going to be read in court regardless of what we do, for example. My idea here was that just as the cumulative impact of disparities at each phase can influence sentencing disparities, you can have this cumulative impact of policies that hopefully will lead to reduce the impact of sentencing guidelines that are overly punitive or overly harsh. The last point, and this is kind of what I think about on a day-to-day basis, is how do we use information technology, research data in a case-by-case world, right? We can inform, track, and evaluate policy. We can try to provide information upfront to inform ADA decision-making and state attorney decision-making. And that's what I spend my time doing. So I appreciate this time, the opportunity to talk. I want to thank all of my colleagues in the data lab, our Penn research team, and the DAO policy team who made all of this possible. And thank you. Look forward to questions.
Yeah. Well, thank you, Warren. And I think it's fascinating that you've got a district attorney with a data lab. That's something that we hope others will emulate and are emulating. And of course, this brings us full circle in looking at different parts of the system. We're going to be addressing some questions here, and I've got some that I want to throw out there, but there's one that came in that I think is particularly relevant to some of the things we've been talking about, which is, do the panelists have thoughts on how Congress could revise sentencing laws to address the weight issues that Mona identified? And this would go for state legislatures too. And this is something that I think all of us have thought about. What's a better way than using weight? I'm posting in the chat something I wrote in 2014 about using profit as a metric to determine culpability. But I'm going to go back to Judge Gertner. What do you think a better way would be to assess culpability than weight?
Well, in the past, weight would be part of the discussion, but the question was, the difference between the major dealer and the guy on the street was, is he living off drugs? I found this so many times in court, is he dealing drugs for the purposes of buying a Porsche, or is he dealing drugs for school supplies? And that is a different crime. We've made the illusion was that the crime was the same if the drug quantity was the same. And of course, that takes motive out of the picture in addition to the other factors I've described. So I actually would, it seems to me that we could characterize major dealer, minor dealer, have a set of characteristics that would be a broader range that the judge could take into account, of which quantity would be one. And then that would be part of the description part, and then we would eliminate mandatory minimums, which is clearly skewed to everything, and reevaluate from top to bottom the federal sentencing guidelines. Other than that, I'm fine.
Other than that,
Right.
yeah, I mean, it was always remarkable to me when I was a prosecutor how many of the people that were brought in as drug kingpins were indigent. They couldn't afford a lawyer. And that said to me that maybe this person isn't really a kingpin, or else they're an especially unsuccessful kingpin.
Right, but we can. It used to be you'd ask the question, and when I was a lawyer, we used to do this. Are you living off? What's your lifestyle, and what does that suggest about how important drug dealing was to you? And that matters. We took out motive out of the calculus because of quantity, and we took out all the other factors that I've mentioned. Just one other point about disparity. I think this was in Mona's point. When I sat for a month in Puerto Rico as a district court judge, And the cases that the Puerto Rican prosecutors would bring were not remotely like the ones that were brought in Massachusetts. The same quantity that in Massachusetts was a big deal was nothing in Puerto Rico. So the federal sentencing guidelines changed. The notion that we eliminated disparity as between districts was just not true. Not at all.
Yeah. And let's turn to Professor Lynch. Do you have any thoughts on that? What would be a better?
Yeah, I think it's really challenging. One of the things that I argued so I wrote a book on my studies of the 4 different districts. Actually, I just focused on 3 in the book. But one of the things that's a problem is the headroom in drug cases, right? So it's the fact that things can get so awful. So the ceilings are as much of a problem as the floors, right? So there's you can hear me, right? Yes. Okay. So I think that's something Congress can address in terms of the statutory maximums, because those statutory maximums allow for that relevant conduct to go up. And then when you go into a district that's very bound by the guidelines, and there still are a number of districts, particularly in the South, where guidelines really matter to judges and they really stick to them. That's one issue. The other is really, I mean, part of it, the commission has to deal with it in terms of using that metric and thinking about, so I completely agree with Nancy's points about thinking about culpability as something, and also sort of the motivations behind it. I think the idea of the non-real weight is so problematic, particularly for relevant conduct, but because the burden of proof is lower, but it also affects the mandatory minimums. To me, it was astounding to find out that this could happen. And, sort of knowing, particularly around the pressures on informants and cooperators to come up with things, the reliability is so low, and the sort of like blind eye to that possibility. So that, I think, needs to be addressed. Absolutely, in some districts, that weight is weight because they're catching people moving drugs in a truck or whatever. In other districts, weight is that there's tons of defendants who've been sentenced under this weight that doesn't even exist. So so I think that part of it needs to be dealt with, but I don't know how. Sentencing Commission has a big role in this, as well as Congress addressing the statutory maximums as well as the minimums on drug cases.
I just want to interject. I would like Oren to work for the Sentencing Commission and ask the question, not what number can we pick out of the air, but ask the question of what works to eliminate the crime or mitigate the crime. In other words, you stopped asking the questions about deterrence and rehabilitation. We're picking numbers out of the air. And Oren, I charge you with doing that.
Oren, your response.
That's an honor. I don't know what, I can't say no. But I think there's many good people who are trying to do that work, and the instinct of using data, right? We have so much information at this point to inform. And I think that's always been the intent, but just as we keep going, you got to iterate and go back and see what the outcomes have been, so that, we can create the change that we want to, right? Set those goals and create that change.
Okay, and Oren, just before you go on mute here, most of the drug cases, of course, come down in the States. What would you want to have change in Pennsylvania?
And again, not speaking on behalf of the office, I got to be careful about that. There's just far too much churn in this area. And to the judge's point, is this necessarily helping people to respond to substance use in this way? I think based on all the research, or much of the research that I've seen, the answer is no. It's not necessarily a very helpful approach. So I think it would just be complete overhaul of how we approach substance use, and that should also occur through changes in the law, because you can't just count on discretion of an elected official, because that can be very ephemeral.
Yeah. Okay, thank you. And I want to there's a question about disparities between judges, which of course is always an issue. And kind of highlighted in a recent analysis by the Sentencing Commission on compassionate release that showed that in the Western District of North Carolina, 1.5% of the cases there were granted, whereas in Oregon, it was over 60%. So, disparity between judges is important. And of course, disparity between prosecutors has been really important as well, something that's hidden because they don't operate in the open in the same way. So of course, anytime that we talk about moving away from mandates, we enter the discussion of how do we control disparities between judges. And I guess we'll go back to you, Judge Gertner, on that to address that question.
Well, let's pretend that judges were like every other discretionary actor in the system, prosecutors and police. Every other discretionary actor, we are trying at least to look at their exercise of discretion, let's say on racial grounds, by studying it after the fact and saying to this police officer, you have only picked up Black people, or saying to this prosecutor, the racial disparities are enormous. What if we did that with judges? Well, enhance discretion and then have after the fact analyses of whether or not that not just did you sentence under the guidelines or not, the binary question, which is really all the Sentencing Commission typically asks, but the more fulsome discussion is what issues did you credit and why? And do that after the fact, share that with the judge. And that's one way of dealing with discretion. The other way of dealing with is in other settings, we talk a lot in Federal Judicial Center and the Center for Law, Brain, and Behavior of the equivalent of peer review. There was a period of time before the guidelines when there were sentencing councils and judges would get together and say, what do you think about this guy? What do you think about this guy? In other words, how do you deal with a discretionary actor in order to make sure that the differences are not dramatic? And there are other discretionary actors. What we've done with judges, what we've done with nobody else, which is to say, you must do this. It's mandatory to do that. And I don't think that that works. The problem with the disparity studies, both the Sentencing Commission and the one recently published by Syracuse, is that it implies that everyone should default to the guidelines. In other words, everyone should default to the guidelines, that somehow the reason for the disparity is that not everyone's a guideline center. And finally, the Sentencing Commission could post on its website examples of what judges have done in paradigmatic cases as a way of encouraging other judges to do that. The Sentencing Commission posts on its website guideline compliance. And so the judge that wishes to diverge from the guidelines is at sea. So there are lots of ways of cabining discretion, but I could go on.
And of course, the guidelines were designed to adjust to what judges were really doing. They just never implemented that part of their mandate. That was supposed to be a big part of it, and
right.
It never actually happened. I was wondering, Professor Lynch, do you have any thoughts on that question of interjudge?
Yeah, I do. I mean, first to your point that there's equally, if not more, discretion going on in prosecutors' offices, not only, particularly in drug cases where the decision to even prosecute is completely hidden and kind of uber discretionary, right?
Should default to the guidelines. In other words, everyone should default to the guidelines, that somehow the reason for the disparity is that not everyone's a guideline center. And finally, the Sentencing Commission could post on its website examples of what judges have done in paradigmatic cases as a way of encouraging other judges to do that. The Sentencing Commission posts on its website guideline compliance. And so the judge that wishes to diverge from the guidelines is at sea. So there are lots of ways of cabining discretion, but I could go on.
And of course, the guidelines were designed to adjust to what judges were really doing. They just never implemented that part of their mandate. That was supposed to be a big part of it, and
right.
It never actually happened. I was wondering, Professor Lynch, do you have any thoughts on that question of interjudge?
Yeah, I do. I mean, first to your point that there's equally, if not more, discretion going on in prosecutors' offices, not only, particularly in drug cases where the decision to even prosecute is completely hidden and kind of uber discretionary, right? And the kind of targeting, particularly in places like Boston, where they were going to certain neighborhoods, looking to sort of pick up the bad guys who, we can't get them on other things, so let's get them on drug stuff, where that stuff is not regulated and it's completely hidden from us. So there's no obligation that prosecutors share their data about what they're doing. What's happening in Philadelphia is a very rare thing to have open data around this. And certainly that would be one thing, is to kind of think about the discretion. And most of what we're seeing, like when we do analyses of the kind of multi-stage discretionary actions, we see a lot happening that affects sentencing that's really those early stage decision-making stuff. And you just, and to pin it all on a judge is to sort of conflate what are a number of decisions that happen before then. And I did some qualitative work around the question of what happened after Booker. And prosecutors would tell me, oh yeah, as soon as Booker came out, we're gonna start threatening mandatory minimums to get the deals we want with and to kind of cabin the judge, particularly on like child porn cases. Like, oh, we'll go out, we'll charge the mandatory minimum if you don't go along with this deal, because we know this judge is like really sympathetic to these and thinks the guidelines are too long and so on. So that kind of stuff that's happening behind the scenes and at earlier stages gets wrapped into those disparities, and it all gets pinned on the judge, which is, to me, unfair. It's really not just a judge's decision.
Yeah. Before we run out of time, I do think we need to talk explicitly about race, something that comes into this. I'm going to start with you, Warren, because you did in your PowerPoint explicitly address racial disparities and reducing them to some degree. How do we get to actually eliminating racial disparities in these kinds of cases?
Yeah, I think that goes back to the very heart of the laws and how a lot of these came about, and the intent and just the history of drug law enforcement in our country, and the very first laws passed here to target opium dens on the West Coast. And it's at the very root of it. But I think what the reason I remarked on that in particular is because there aren't that many studies that can identify those types of reductions, especially when you're doing reform. Often you see that as you reform systems, disparities can become even worse, right? Like as the jail population has gone down in Philadelphia over time, some of the racial disparities and disparities in terms of people with mental health conditions who are in jail, those just get worse. The proportion of people with serious mental health issues in jail has increased over time as we've tried to reduce the jail population. So I think those are examples of endemic problems that we have. And I think part of the solution is to do the math, look at the data, and specifically craft policies that take the disparities, take the racism in the system head on. And I leave it to lawyers who know better if you can actually do that, right? There are some potential limitations there. And that I think is also, problematic, or maybe that's, again, just the system and how the system works to kind of limit the ability to take these issues head on. But that's the key, I think.
Yeah, and I definitely want to hear from our other two panelists on that. I know Professor Lynch will start with you next, but you've written extensively about racial disparities and the creation of them and some types of crimes. What is our way out of that problem?
Well, it's I mean, the drug, I think for the drug war, we'll call it what it is, that has been racial as we just heard from Oren from the start, and it gains its power through the ability to sentence people to a long time and to manipulate people into doing things like becoming confidential informants and so on. So there's, of course, there's incentives built into policing around, and this is documented at the state level, local level, and even down to misdemeanors into, going out and doing proactive drug work, because there are certain things that come with it. There's things like, forfeiture and so on that, have this kind of ugly history in our country. But in the federal system, which I've been studying the most, I've actually studied some kind of frontline policing in the state system. But at the federal level, it's really that uber discretionary stuff that started in the 1970s, right? By opening up this ability, the kind of federal jurisdiction over what are really state and local cases, that kind of opened up the possibility of the feds going after low-level drug dealers, and then that opens up the possibility of using that to sort of develop, networks of confidential informants and cooperators and so on, and kind of create this monster. So I think that the incentive structure for going after drugs in one of my districts, the Northeastern district, the very liberal district, judges would refer to the small drug cases as low-hanging fruit. They're super easy for prosecutors to make. The conspiracy law in the federal system allows for really easy cases to make, and generating lots of defendants, getting numbers up, and so on. So the solution to it is less regulation of drug and less punitive regulation of drugs. And what that looks like across all the many jurisdictions.
Let me just let Judge Gertner close us out on this. I know this is something that's informed her work.
Well, I mean, it's as if the judges in this system were the caboose, and all of the decisions have been made long before the caboose. And so the question is, what can a judge do at the end of the line? Mona is talking about prosecutorial decisions and legislative issues. That's one thing. What can a judge do at the caboose? If you gave me more discretion to sentence, I may be able to examine more carefully issues like selective enforcement. I may be able to examine more carefully issues like sentencing entrapment. I may be able to ask questions of the prosecutor, as we're asked in Chicago, about a stash house that was contrived by the government and put in a Black neighborhood. I did a little bit just trying to deconstruct the guidelines. I wrote a decision on driving while Black, and I wouldn't credit what was clearly a traffic offense that only a Black man in this jurisdiction would have gotten. So if there are obviously many more changes at the front end, but clearly if you tie a judge's hands so that we really are the caboose and all we're supposed to do is calculate drug quantity and criminal record, there is no way we can examine these issues. So I want the caboose to have more power.
Thank you. I think that's a fine place to end since we're out of time anyways. But I'd really like to thank our panelists. I think this was a fantastic discussion, and I just wish we had more time, and going forward, I hope we will. Thank you.
Thank you, Mark, and thanks everybody
Thank you, Mark.
for coming.
Thank you so much.
Thank you.
Bye,
Great
Aaron.
to be on the panel. You take care.
Thank you for attending Cannabis Crossroads, What's in Store for Marijuana Reform in Ohio, hosted by the Drug Enforcement and Policy Center at The Ohio State University Moritz College of Law and the Natural Therapies Education Foundation. Before we begin, we have just a few notes we'd like to share with you. First, to streamline the appearance of the event today, we suggest that you hide non-video participants. To do that, click on the three dots at the top right corner of any participant box that has their video off and click Hide Non-Video Participants. Second, we want to draw your attention to the Q&A function at the bottom of the Zoom window. You may submit questions at any time during the presentation. Third, please note that auto-generated transcription has been enabled for this event. To change how you view the automated transcription or to hide it, click Live Transcript in the menu at the bottom of the Zoom window. Finally, this event is being recorded. The recording will be made available on the event page and on social media channels as soon as possible after the event. Follow us at OSU Law DEPC to stay up to date on our research, programming, and future events. Thank you again for joining us, and we hope you enjoy the event. Doug?
Thank you, Holly. I appreciate it very much. And hello to everybody. Thank you To all the attendees, I'm extraordinarily excited. I'm Doug Berman. I'm the faculty director of the Drug Enforcement and Policy Center here at the Ohio State University Moritz College of Law. And I really do sort of think our whole center came into being with a vision for a program like this at a moment like this. Specifically, our center looks at a variety of drug policy issues, but gives sort of marijuana reform extra special attention. And one reason for that is not just how dynamic this field has been, but because, as all the panelists here know, probably everybody attending also knows well, it's not just a will reform happen or not. The details matter, and matter incredibly importantly on the policy front, on sort of just good law development fronts. And so I'm extraordinarily excited that as marijuana reform heats up even more in the great state of Ohio, we're able to do this program with 4 terrific speakers who can give insights both on the ground of what's happening here in the state, but also provide a historical and a national perspective on both what's going on and where we may be headed. And so let me briefly introduce all the panelists so you know who you're going to get to hear from, and then turn to them sort of in an order of kind of providing background and opportunity to locate where we are now in context and forecast perhaps where we're headed on marijuana reform in the state going forward. So we have, in alphabetical order, Mary Jane Borden, who's the co-founder and secretary of the board of the Natural Therapies Education Foundation. And right before we got on, she was described as an OG in this space. And I think that's a perfect modern way to think about the work that she's been doing in Ohio on these topics for decades. Then we also have Tom Herron, who's a partner at Franz Ward, was involved in the 2020 effort that got necessarily curtailed by COVID, and now is at the forefront of current initiative efforts to bring adult use marijuana reform to the state of Ohio, and has been active as a lawyer working on the current medical campaigns and licenses. Then we have, fortunately, Shailene Title, who is a former Massachusetts Cannabis Control Commissioner, and we've been very lucky to have her at the Drug Enforcement and Policy Center as a distinguished cannabis policy practitioner in residence for this year. And finally, certainly last but not least, because he introduced the first official bill to reform through the traditional legislative process, marijuana for adult use, that's Representative Casey Weinstein. He's House of Representatives, District 37, that covers part of Summit County. Let him talk about his perspective there as well. We're going to actually start, though, with Tom Herron, because I think, Tom, you can likely provide some background on your group's efforts before this year to get these issues to the voter through the initiative process, and then the ongoing efforts, as I understand it, to collect signatures and present through the direct democracy process a chance for Ohio voters to get to adult use recreational reform. And so with that, I've told each of the panelists that they've got 5 to 10 minutes that it will be liberally construed by me as the moderator. Then we'll have some time for some back and forth and some questions, and then also questions for the audience before we wrap up. So that's the game plan. And with that, I'm going to hand it over to Tom to get us started.
Great. Thank you very much, Professor. And I guess before I start, I do want to thank Professor Berman for all of his hard work in providing these platforms to talk in settings like these about marijuana reform. To the extent that Mary Jane Borden is one of the OGs of the industry, certainly Professor Berman is one of the OGs of marijuana academia, and all of the hard work that the Drug Enforcement Policy Center is doing is really terrific and really helping advance this issue forward. So first, I'll start with the effort that we had in 2020. That effort was a constitutional amendment effort that, we started the process of gathering signatures and submitting our proposal to the Attorney General's office right in March of 2020, like literally right before COVID hit and everything in the world shut down. And for a constitutional amendment, to get on the ballot, you have to submit over 400,000 valid signatures. And it became really hard to do when all of the public events were shut down, restaurants were shut down, etc. So we really lost an opportunity to gather signatures in big groups. And believe it or not, people weren't terribly excited about going door to door in the middle of a pandemic either. So that effort sort of fell by the wayside. and a similar effort began earlier this year with a very similar name, the Coalition to Regulate Marijuana Like Alcohol. The biggest difference between the two is that this effort is an initiated statute effort, which means we are in the process of gathering signatures, which we expect will be completed probably about the end of November, to then put a statute proposal before the Ohio General Assembly. And once that happens, the Ohio General Assembly will have 4 months to pass the initiated statute proposal as is. And if they decline to do that, then we have the effort to put it in front of the voters in November of 2022. And our proposal really builds on the existing infrastructure that we have in the current medical marijuana program. Under our proposal, it would be legal to possess up to 2.5 ounces of marijuana and 15 grams of marijuana extract. And we would also provide a framework for the issuance of new adult use licenses. And because we're building on this existing framework, it allows us to provide an alternative to the unregulated market as quickly as possible. So within 9 months, you will see, if enacted, a number of new adult use dispensary licenses, of which 40 adult use marijuana cultivation licenses would be issued with a preference to social equity applicants, which I'll talk about in a little bit, and up to 50 new adult use dispensary license, again with a social equity preference. And those licenses are on top of adult use dispensary licenses that would be granted to existing license holders as well. And then after 24 months, the state of Ohio, through a new division of cannabis control, could reevaluate the market and issue additional licenses at that point. It was very important to our coalition to have a robust social equity component of this proposal. So we wanted to make sure that there were opportunities for social equity applicants to participate in this new industry. But we also wanted to make sure that we were moving this concept of restorative justice forward as well. So under our proposal, the Department of Development will create a new social equity and jobs program that will certify social equity participants based on the wealth of the business or the business owners, social disadvantaged based on membership in a racial minority group, the participants' color, ethnic origin, gender, physical disability, or long-term residence in an area of high unemployment. You could also be certified as a social equity participant if you, your spouse, child, or parent have been arrested for or convicted of or adjudicated delinquent for a marijuana-related offense. And you could also be certified based on economic disadvantage based on being in a qualified census tract. And then under this social equity and jobs program, the program would provide financial assistance like loans and grants to participants in the program who are applying for or who are issued a social equity license. We would encourage social equity hiring practices within the adult use marijuana industry. We'd also study and fund criminal justice reform efforts like bail, parole, and sentencing reform, expungements, sealing of records, legal aid, and community policing. We would study and propose reforms to address the social and economic impacts that the war on marijuana has had in Ohio. And I think most importantly, the program would fund direct investment in disproportionately impacted communities to enhance education, entrepreneurism, legal aid, youth development, violence prevention, and the arts. And this program would importantly be funded by new tax revenue generated by the adult use marijuana industry. And the way that our proposal is designed, there would be a 10% tax applied at the point of sale of adult use cannabis to a consumer. And all of that tax revenue would then go into several buckets. 36% of that new tax revenue would go directly into the Social Equity and Jobs Fund. 36% of the tax revenue would go into a host community cannabis fund, which is designed to provide tax revenue to municipalities that host adult use dispensaries so that we can ensure that we have dispensaries in communities across the state. One of the big problems with our current medical program is lack of access. We don't have enough dispensaries, and we want to make sure that in an adult use program, we encourage communities to participate so that their residents have alternative access other than the unregulated market. And then an additional 35% would go directly to fight substance abuse and opiate abuse specifically. And when we talk about that tax revenue, the first question we always get is, well, how much revenue are we really talking about? And there was a paper written by Finley L. Newman James, who at the time was a student at Moritz and was active in the Drug Enforcement Policy Center. And this paper estimated that if Ohio taxed an adult use market at 15%, like they do in Colorado, and had similar usage rates across its population, that an adult use market could generate near $625 million annually in new tax revenue. So our tax percentage is 10%. And so we think using those estimates that an adult use market could generate north of $400 million annually in new revenue to the state. So when we talk about social equity, that means that our social equity and jobs program would be funded with about $144 million every year. This would be the biggest investment, I think, in state history with an eye towards social equity. So again, we think we've taken meaningful steps to further the restorative justice aspect of a new adult use market. And one of the other things that's really important in an adult use program is home grow. And our proposal would also legalize home grow and authorize an individual to grow 6 cannabis plants in their house, or if there are 2 or more adults in a residence, you could grow up to 6 cannabis plants. And just like in almost every other state, we want to make sure that home grow or homegrown marijuana is not accessible to minors. So we have the same similar sorts of controls that you have to grow inside a secured closet, room, or greenhouse in a way that's not accessible to people under 21. So with all of these proposals combined, we really think we have sort of a best in class proposal, taking ideas that have worked in other states throughout the country and bringing them all together in a real cohesive manner that would really, we think, be a great thing for Ohio, a great thing for Ohio's marijuana industry, for consumers as well.
Thank you so much, Tom. That was extraordinarily helpful and a great overview. There's so many particulars I know to cover. I do want to make sure I don't forget to highlight that at the Drug Enforcement and Policy Center's website, we've produced a chart that details the existing proposals, compares it to Ohio's existing medical marijuana program, and you should definitely go there. We'll get it in the chat, the specifics of where you can download the chart and also see some other efforts we've made to make it easier to get through, all those particulars between the initiative and the current HB 382 that Representative Weinstein has proposed. And I'm going to turn to him in a minute, but I'm going to kind of do a bridge between them with one follow-up question, Tom, particularly as I kind of think about the initiative process. First, I want to confirm, because I was unsure about this, your plans are to get the signature gathering done by the end of this month so that by December it'll be in front of the legislature and they have that 4-month window, as I understand it, to act or fail to act on the proposal, at which point, if they don't act, you then collect more signatures to try to get on the ballot by this November. Is that an accurate description of the timeline you're hoping for?
Yes, it is.
And then the follow-up, and this is the one I've heard from a few people, with this being an initiated statute rather than a constitutional amendment, is there concern, or my understanding is it's possible that even if the voters were to enact the specifics you just described, but then the General Assembly next year decides it doesn't like the social equity parts or doesn't like with the tax structure that the initiative has, they can just pass legislation and alter that. Is that correct, or a worry? And what can be done about that? If if voters obviously vote for this and like the particulars, but then there's a risk that they don't stay in place very long.
Yeah, so at the end of the day, that's not something that I'm terribly concerned about, and maybe Representative Weinstein could talk a little bit more about the internal dynamics in the General Assembly. But we've started the process to engage with legislators on this topic. We think that marijuana reform is popular. It's popular across the country. We think it's popular in Ohio. We think it's, at this point, not just a bipartisan issue, but really a nonpartisan issue. We think it's something that legislators recognize is basically an inevitability. And the real questions are, when will Ohio take this step, and how should Ohio take this step? Professor, as we've talked about before, the federal government, I think, is going to move on this issue. There are now, both Republican and Democrat sponsored bills moving through Congress. This has been a priority of the Biden administration. Vice President Harris, I think, in sort of a monumental statement in the vice presidential debate, said that decriminalization was a priority for their administration, which I think was the only time we've seen a vice presidential nominee of a major party make a statement like that in a national debate. And the timing is really important here, because in Ohio, we have a statute, like many states, that says if the federal government adds a drug to the Controlled Substances Act, if they remove a drug or they change the scheduling of a drug, that change is automatically affected under Ohio law. And states have that because the FDA, routinely approves new drugs or new research and things come out. But what that means is that if the federal government deschedules marijuana, it would be automatically descheduled in the state of Ohio. And at that point would be completely unregulated, completely untaxed. There would be no restrictions on where it can be grown, no restrictions on pesticides or labeling, no restrictions on whether you can or can't sell to minors, importantly. So the timing here is really important, because the choice really is, who's going to make the decision whether or not to legalize marijuana for adult use in Ohio? Is that decision going to be made in Washington, D.C., or is it going to be made here in Ohio? And if it's going to be made here in Ohio, which we think it is, we think that that's a decision that the legislators should make in the General Assembly, and that's why we've taken this path towards an initiated statute.
That's a wonderful segue to Representative Weinstein, who I assume agrees the legislature should be making the change here in Ohio. And so, with that, I'll just sort of give you whatever opportunity you want to take to describe your bill or the legislative process going forward, because I think that's itself part of kind of what's an uncertainty and a challenge. We've heard other folks in the General Assembly talk about possibly putting forward a bill, but you deserve credit, along with Representative Upchurch, for actually putting forward a bill. And so we'd like to hear about that, and probably hear more generally about your sense of what the current General Assembly is thinking on these sets of topics.
Thank you so much for having me. It's great to be here. My sense, Rep. Casey Weinstein from Northeast Ohio in the 37th House District. Essentially, I'll start by saying we've reached a tipping point, and over the past year or so, I've had conversations. A couple things. I've watched as states, including what I would consider peer states like Michigan, legalize or decriminalize and move forward. We've reached a tipping point where we're almost at a point where the majority of Americans live in decriminalized or fully legalized states. We had what I would say is like a seminal Pew poll that came out, I think it was April of this year, that had 91% of Americans supportive of either full legalization. It was over 60% for full legalization, and an additional 30 or so for medical legalization. And across all age groups except 75 plus. So we got to work on them. But support for full legalization across all groups. So, and then just in my personal life, my mom suffers from multiple sclerosis. So this has been something that I know has impacted her positively. Talking to my friends, frankly, I don't smoke, but talking to my friends, honestly, they do, and or use different marijuana products. And we've also got a robust and growing, stable and growing medical program here in Ohio. So when you take all this together, it's really clear to me that we have reached a tipping point. And I should add, and Thomas did a great job of providing an overview and talking about the bipartisan / nonpartisan nature of this. It is one of these few issues that has so many reasons to like it from so many different interest groups, that it's the nonpartisan issue, or it's widely popular on both sides of the aisle, all sides of the aisle. So it's time to move forward, right? And we're at the tipping point where if we don't, we really stand to lose out ultimately. So that's why I decided with my good friend and colleague, Representative Terrence Upchurch, to move forward. The ballot initiative, I'd love to get this done legislatively. It doesn't mean I don't in any way support the ballot initiative. I think it's initiated statute is a great way to go, because voters want this, and a lot of times the voters want things and the legislature is holding them back. And this is a situation where we're behind where Ohioans are. So, and I'm sorry, my dogs are going on. I don't know, it might be some reefer madness. The police might be closing in on my house right now. We'll find out here. But we have, I think, a momentum from the initiated statute and a compelling reason for the legislature to take action. And indeed, my colleagues on the other side of the aisle have announced a framework to do just that, to move forward. So now we have three initiatives moving forward. So I just start by saying we are absolutely at a tipping point and then we have the federal movement as well. So we're at a tipping point where it's time to get this done and time to move forward.
Yeah, I'm tempted to joke the dogs are sort of like the State of the Union, audience, where they just want to clap every time you say something they agree with. But let me ask a couple follow-up questions to you, because I suspect, especially most of the folks tuning in and certainly all the speakers agree with that notion that the time is now and this is where all the action and momentum is. But my understanding is all the key legislative leaders in the state, the heads of the House and the Senate, as well as our current governor, are less than enthusiastic, if not quite oppositional. And I believe there was a recent quote from at least one of the leaders that Ohioans weren't ready for this yet, or something along those lines. And so, can this move forward without leadership? Obviously, what a initiated statute approach allows the voters to say, we want this, even if the legislative leaders are oppositional. But is your sense that you'll be able to get hearings, you'll be able to move forward and bring leadership along, or is it, that the kind of impediment that's going to require a change in leadership before we can expect to have this done through the normal legislative process?
So there's a stray dog that is just like out in my yard, and my dogs are going nuts. So you're just going to hear them going nuts upstairs, and there's nothing I can do about that right now. But anyways, so yeah, I mean, you took the words right out of my mouth, right? The initiated statute provides the urgency for the legislature to take this up if we want to have a say as elected officials in what this looks like. It so happens that my bill and even the Republican bill mirror fairly closely the framework of the ballot initiative, but that is the ultimate reason for us to move forward and do this through the legislative process. We were recently assigned to the Finance Committee chaired by Scott Olslager with Ranking Member Bride Sweeney, and recommend reaching out to their offices to urge hearings. We weren't meeting for quite a while over the summer when we filed the bill. There's a big backlog of legislation. We're about to start on the capital budget. So it's crowded, right? So that kind of energy and momentum behind it can help. Hearing from people on both sides of the aisle can really help us make the case. Things like this, just additional momentum that helps us move forward. So I think the fact that we have two bills, that we have federal legislation moving, that we're losing out on on vital funds to our neighboring states, and that we have a path for the voters to weigh in, which I'm confident that would pass overwhelmingly. That initiative will provide us the opportunity to get hearings on this late this year, early in the new year.
Wonderful. And I'll do one last sort of follow-up question that piggyback is a little bit off of a question that was in the Q&A to Tom, but to you as well, because you mentioned sort of growing support or events like this helping with the cause. Is there a specific way that Ohioans, individuals, whether it's policy groups, whether it's other kinds of individuals getting their voice heard? Is there a more or less effective way? Is it petitions? Is it saying they're going to vote in a poll in favor of Tom's proposal? Is it just writing letters to their representatives, getting their voice heard? Is there a particular kind of advocacy in this setting that you think is particularly important? Or, and to some extent, I'll reflect my own fear of some of the stigma that still exists in this space. Is there a certain kind of rhetoric and advocacy that may be counterproductive, at least in terms of the ways in which, as is true, I think, in every field, certain advocates who are especially passionate may push harder than particularly certain legislators are comfortable with? What's your sense of kind of what can move the needle here, and what risks moving it the wrong way?
Yeah, it's a great question. I put in the chat the contact info for Rep. Olslager and Phil Plummer, who's the vice chair. Because Bride Sweeney, who is my Democratic colleague, is going to be supportive of getting this bill hearings. Reaching out is good. Social media is good. Elevating what Rep. Upchurch and I are putting out is good. At Rep. Weinstein, by the way, on Twitter or Facebook or Instagram. There are definitely diminishing returns. If you were to reach out, I'd say reaching out once is fine. I've had great constituencies behind some other legislation that I've worked on, and depending on the legislator, they can get temperamental and kind of like it can have diminishing returns if the same person may be reaching out over and over again. But I think just sharing a personal story about the impact of this, my bill, I didn't really give it an overview. It is fairly similar to the ballot, but it allows for personal growth. It allows for personal possession. It expunges records. It creates a marijuana regulatory committee that will purposely, and intentionally go into communities that have disproportionately been impacted by marijuana prohibition. It'll re-enfranchise people and allow them to participate. It has a 10% excise tax, and the funds for that go directly back into the communities that host the retail locations. So it's even talking, or for the on a personal level, what that could mean to your community, what access to this could mean to you, to having more locations. Because right now in our medical program, we are severely limited on the number of dispensaries, and people are in medical marijuana deserts. So what does additional access mean from an affordability perspective? What does it mean to have home grow? And sharing those stories is powerful, and reaching out to your legislators matters. Follow them on social media, send a message through their page, email them, or call the office, or write a letter. I just pick one medium and sort of temper the outreach, but do it, right? And then keep elevating these messages of why we should do this. And it sustains and builds momentum to get hearings and ultimately to move this through the process.
Wonderful. And I may circle back to you before you have to, I know, leave us unfortunately at 1 o'clock, but I'll have one question particularly about data that might be a follow-up after Shalene has a chance to talk about her experiences. But before that, I want to let Mary Jane have her chance to talk about, her perspective, which extends, decades, and maybe she also can talk about what she's found effective and maybe less effective at times, and when it comes to trying to lobby the decision makers here in the state and beyond. And so thank you very much, Representative Weinstein, and keep putting in the chat all of that as well. It's very valuable, especially for younger folks to understand fully how powerful their phone alone can be without having to do more than that, and following and commenting in that forum. And so Mary Jane, we're the OGs according to Tom, and I'm happy to share that moniker with you. I'm even happier to give you the chance to sort of give your perspective both on how far Ohio has come already, but where you see it going, and your take on the proposals that are afoot and the prospects for actual reform getting done in the coming months and years.
Well, thank you for inviting me to speak today, Doug. I'm grateful to meet Representative Weinstein and Tom Herron, and of course Shalene, who I've known tangentially for a few years. So what I thought I'd do is compare some of the things that are going on with what we call the Gong War poll. This is an organization that has been doing polls of the High General Assembly. This is not a public opinion poll going out to the rest of the world. This is kind of in the bubble of the General Assembly, and to try to take the temperature of them on various issues. And they're covered, as you see right now, they're covering what they call recreational adult use marijuana on the poll that was just recently released. I believe that Holly's going to put that in the chat if anybody would like to follow along with me. In other words, the link to it on their site. So let's get started here, because you look at the first question, which it would be, should adult use marijuana be legalized in the state of Ohio? Well, I'm going to get political because I almost have to. We're in a the legislature, and what is it? It's political. Okay, so we're going to talk about Democrats and Republicans here. Okay, 36% of the Democrats say yes, that adult use should be legalized. Okay, and we have about 50% on this side. I call them like fence sitters, and then we have only 14% saying no. Conversely, a larger percentage, 43% of Republicans are saying that marijuana adult use should be legal. But on the balance of that scale, we see 43% saying no. All right, and they're not very much undecided on this. And so I think that largely the 43% of the Republicans have that, have that libertarian bent, and I would say that's reflective of them. But if you're seeing that this particular, I think the whole overall, there's only, if you take the General Assembly as a whole, there's only 40% that are favoring adult use. All right, and if you see that as wishy-washy between the nose and the undecided, you're right. This has been a historic trend in the legislature. And they're obviously not listening to their constituents, because the recent Gallup poll showed 68% of Americans supporting adult use now, which is a huge jump from years ago. And before I go any further, I'm going to note that stuff I'm talking about here next, I've actually been involved with. I was lobbying the legislature during the 2000s. I've run ballot initiatives. So that's kind of a personal story of my own, that I'm kind of been in the weeds concerning these various methods of legalizing marijuana in the state of Ohio. And so, as I said, legislative transience is kind of part of the bill, and it's part of a history of legislation in Ohio. And I think another thing construct to remember here too is that both chambers of the legislature have been Republican for years. I mean, decades. Okay, so this is the dynamic we work with. It's kind of more important to look at their numbers than it is with the Democrats, because they're going to be driving the ship here. Okay, and so also we look at the administrations. We had of course, we got the wine right now in the governor's mansion, and then we had I can't say Representative Kasich, but had Governor Kasich before that, Governor Strickland before that, Governor Taft before that. So that these metaphors that we're talking about with respect to where the legislature stand has crossed over various parties being in control of whether it's the really mostly the governor's mansion outside the legislature. So that's what we're looking at here dynamically. So from 2000 to 2015, get this, 7 medical marijuana bills were introduced into the Ohio legislature. Okay, then they were done by Democrats. There's been Senator Hagan, and then Senator Yuko, who's now Representative Yuko, who's now Senator Yuko, and principally were the sponsors of these bills. Only one of those 7 ever got a proponent testimony hearing. Usually your sponsor will get an automatic hearing, but to go further than that, you get proponents to come in, as we saw in other legislation. Only one over 10 years and 7 bills. All right, talk about legislation trends. They said there was no really success until we got to 2015 and HB 523. Well, it's hard to tell the story of HB 523 without telling the story about ballot issues. Okay, so ballot issues. All right, according to the High Attorney General's website, and this is only since 2006, over 20 different petitions have been put before the High Attorney General for certification to gather signatures. Okay, You have to, the process is you write your language, you submit it, and they have to determine whether the summary matches the full text, and blah blah blah. That's kind of the quick summary of the procedure. And most of these 20, with exception of Tom's, were constitutional amendments. In other words, modifying the Constitution to put the law in the Constitution. That's generally perceived as being, irrefutable. You can't really have to change it. You have to go back to the Constitution, or the initiating statute process, which is Tom is doing, is putting it before the legislature. Okay, there are 20 petitions. Of those 20 petitions, 10 were certified. Okay, so that could collect signatures. And only one of those 10, only one actually collected its requisite signatures, went before the Secretary of State's office, submitted them, and got placement on the ballot. That was the infamous Responsible Ohio in 2015. Okay, and it's like in this space, if you don't know who Responsible Ohio is, you need to go back to your kind of the grade school level of the movement. So, and that's, in case you don't know, that was what they call the Monopoly Amendment. All right, the Monopoly question. So the dynamic that Responsible Ohio, there were many dynamics Responsible Ohio encountered, but one of them was that the legislature, I guess, angry, if you will, that a ballot issue had superseded them, that they didn't like the model. They put in their own, I think they passed this in about a week, their own resolution to put their own measure on the ballot to initiate what they call a monopoly question. Going forward, every single ballot issue has to now be evaluated on the monopoly question because it passed. It was called issue 2 and it passed. But Responsible Ohio issue 3 that year were lost. It was defeated. So we got the ballot, the monopoly question, but we got no medical marijuana, or really they had adult use component. So that's what it illustrates here, that the ballot issues face enormous obstacles, not only with the signature gathering, but with the hostile sometimes legislature, because you are doing an end run. And so still, they came back. I think some of them did, not all of them, but they came back in 2016 with a ballot issue. I'm not sure they were behind it, but the Marijuana Policy Project was, which is a national organization. And the ballot issue was called Ohioans for Medical Marijuana. And it began collecting signatures. I think it was certified probably around April, and it was had a very robust campaign, was very involved in collecting the signatures. Most people felt they would make the ballot. And all of a sudden, the Ohio General Assembly wakes up and says, wait a second, these people are actually going to put a constitutional amendment for the people on their own without us. And we're going to have to abide by it, because when it's in the Constitution, they don't get the right to change it. Okay. And it was like all of a sudden, the sleepy legislature wakes up, and again, kind of like in 2015 with issue 2, all of a sudden they get their act together, and within, I think, about 6 weeks passed HB 523. Okay, it was like introduced on the, I could get the exact dates here. Introduced on the 14th of April, got to the House, passed May 10th, approved by the Senate on May 25th, case signature on June 8th. I mean, bam, bam, bam. So and after 16 years, 16 years, and they did it in 50 days. We waited 16 years, which I calculate out to be 6,000 days of waiting since 2000 for medical marijuana in Ohio. And so what motivated the change was obviously the ballot issue. And I think this is similar to what Tom is doing now with ballot issues. Okay. Now, I think he's spot on. If you're going to get your mission, it doesn't cost you quite as much money and effort with the signatures, but you could get it before the General Assembly much more quickly. Okay.
And Mary Jane, as you're talking about that, I wonder if you want to comment on, and I want to make sure it's mentioned in our conversation. There's a new bill to significantly expand Ohio's existing medical marijuana program. Do you think that's a direct product of the initiative campaign that's going on, or do you think, you know, that I'm wrong to speculate the same kind of dynamic is in play where certain legislators, you know, seeing what might be on the horizon are trying to kind of get in there and have their cake before somebody makes them eat it?
I like the analogy there. I hate to be so cynical to suggest that Senator Huffman is just doing this to gain political points, but the timing is really interesting. And he covers many of the same things that are in the initiatives. Of course, they won't have, the home grow will be one thing that will not come out of Senator Huffman's bill. But I think some other things, such as revising how the qualifying conditions work, so that you don't have to have that little set, being that set box. You know, you have something that a physician actually recommends, and that's very important to people who have rare disorders. You know, I could go on describing the things that are good about that bill, but you know, you do have a scratch your head moment going, particularly now that I hear that Tom is going to is targeting probably December to put his statute before the legislature. The timing is kind of suspicious.
Well, and I don't mean to suggest any sort of untoward motivations. I just think your whole discussion kind of elevated, and I think it's a very important part to understand in this context, the way in which initiative efforts and the traditional legislative process sort of are in dialogue. And sometimes that's a tense dialogue, or, you know, but that's in many respects why I'm a big fan of direct democracy, is it's a way in which you can move a conversation forward more quickly than it might otherwise when there's an opportunity for the people to speak directly. And maybe this is a good time to shift over to Shalene, especially because she's had a role trying to create regulations in the wake of a ballot initiative in Massachusetts, and also has been looking at these issues across the country. And so I'm really eager to get your take on, you know, kind of where Ohio is and where it might be going, and certainly advice for everybody about how we can make sure we do it the best possible way.
Great, thank you so much. And I just want to acknowledge at the beginning, if you are new to this and catching up, or if you're outside Ohio and you know that it has important national implications and you want to understand what's going on, I really recommend the resources from my colleagues here at the DEPC. The comparison of the bill and the initiative and the existing law is really helpful. And just in general, you know, it's really great to come here after being a regulator, because I think as a regulator, you dream about a resource where everybody could have access to the information, where you can elevate the dialogue to one like this. And it's so nice to see that Ohio has that. I also want to acknowledge Tom and Representative Weinstein for taking the time to be here, talk about the different proposals and demystify this process for us. It's really nice to understand this better. And then of course, Mary Jane Borden, I always stop and respect the OGs who have been doing this forever, long before it was cool or profitable. There was an email list that way predates social media that was on drug policy that I know Mary Jane was super active in. And I just tell people, if you like legal cannabis, you have people like her to thank. So this is a great panel. Thanks for having me here. I enjoyed looking at the Ohio proposals because I think in general, they do reflect a lot of learning between 2012 and now. I worked on the Colorado campaign, and I can definitely see the progress, especially home grow. Lots of people talked about this. In my work, not only is home grow really important as a consumer right, but also as a check on monopolistic behavior and corporate accountability, because you always have that alternative to grow at home. And I think that the tax provisions in both of these alternatives are great. There's a lot of specificity here. There's a lot of thoughtfulness as to where it will go. I think the first states, and Massachusetts in particular, we were very loosey-goosey as to where the tax revenue would go, and it's caused a lot of problems. We all are going to have different opinions, of course, as to where it should go, but I really like the specificity. So I mostly work on social equity, and I also think it's an important thing to comment on, because if you zoom out and you look at where we are with legalization, I would largely say it's been a success, except for social equity, because of course it's really difficult to undo damage that has been done for decades, not just by drug laws, but by tentacles that have spread affecting jobs, housing, custody matters, all of these different ways that generations have been harmed by the drug war. And so it's a lot to try to fix it. And we only started trying, just a few years ago with Massachusetts and California, and now New York, New Jersey, Connecticut, so many other states centering social equity. And so I think I would say my big headline reaction from looking at the proposals is that it's great to see social equity acknowledged, but I think we could do a lot more at this point in 2021 to implement the lessons that we've learned, especially in places like Massachusetts and California. So typically with social equity and repairing that harm, we're talking about three different things, which is three different parts of government, and that's expungement and criminal justice, which it's great to see both of the proposals include, and then designating cannabis tax revenue to repairing harm in those disproportionately harmed communities. And then lastly, jobs and licensing assistance. And it's great to see again that the initiative proposal has included this. But what I would note is that it uses language that we actually wrote here originally in Massachusetts that talks about a positive impact and promoting the disproportionately harmed communities as part of the way that you implement legalization. And when we wrote it in 2015, it made a lot of sense because we were just starting to look at social equity and seeing the data come in from the first states to legalize. We were in a different societal dynamic, I think, back then. When I was working on the initiative in Massachusetts, we had the same situation where we weren't sure what the legislature was going to do. And there were 2 people of color on the entire committee. And when you work on a ballot initiative, you have to think about who's paying for it and who's going to pay for all the signatures to be collected. And there's a delicate balance there as well. So I think that from 2015, that was probably a groundbreaking provision to now, there's a lot of improvements that could be made. Specifically, there are comprehensive equity programs that have been put in place since then that are a lot more specific. If you look at Oakland, you see not just set-asides for licenses for social equity applicants, but also legal and accounting services, technical assistance, property, and all of these new benefits that have come up as a result of watching how the applicants face challenges and what they ask for. So I think being more specific or creating a process to add those benefits would be terrific. And then I would just close with, I think a big thing that we learned in Massachusetts and California especially is that when you have strong benefits for existing medical operators, that can really make a social equity program suffer or fail. And that's not an ideological position. It's not one that I held in 2015. It's based on data and evidence. It's based on what we've seen in all of these states. And so I do think it's concerning to see a playing field that instead of being leveled, we're seeing major benefits for existing medical operators, either a right to a license or a priority period. That doesn't bode well when we're thinking about how new entrants and small businesses are going to survive. I think there's great reporting out there from Jackie Borchard about the existing consolidation that's taking place in Ohio in the medical industry. And if we're aware of that, we can learn a lot from what other states have faced and potentially have better program for small businesses, people of color, and social equity programs.
Wonderful. Thank you so much, Shalene. And I want to both sort of wrap in a question and get Representative Weinstein in with the last question before he has to go. That really kind of connects to data and definitions. And so I'll see if I can put these together effectively. Social equity can mean a lot of different things to a lot of different people. For some, it's being making sure there's a diverse representation in the industry. For others, this is kind of my criminal justice side. Lots of people getting expungements or record sealing and trying to undo that part of the past. In your experience in Massachusetts, working on these issues, looking at other states, for example, were there particular data points, or this is one of our concerns, I think, from our center, that just data is not great on any of these frontiers. And one of the things that I want to make sure Ohio does as it moves forward here is builds a data infrastructure as well, whether that's defined in terms of, how many record sealings are taking place, or who's working in the industry, or whose owner has ownership for a variety of the firms. So I'd like to know on the social equity piece, particularly, if there are, sort of data points, or when you're comparing who's doing well in this space, kind of what you look to. And then that I'll transition then to Representative Weinstein to just ask, with folks who are either, not actively supportive or even resistant to reform here, are there particular data concerns, or are there, I saw in the Q&A, somebody's asking about addiction rates. Other folks are I know, concerned about driving under the influence and youth use. What you're hearing in terms of what folks may say and push back to you about their concerns, and whether there's a data answer or it's something else. And so that's a long-winded answer question, trying to get kind of both of you wrapped into a data conversation, but hopefully it makes sense. And Shalene, why don't you give your social equity take, and then Representative Weinstein, we'll hear if the dogs are still barking about it.
So our statute in Massachusetts lays out a research agenda. And so masscannabiscontrol.com has information on everything from baseline to youth usage rates to everything social equity. And it really helps, because as we watched our programs not working, I think it's something like 8% of current applicants are in the social equity program or otherwise disadvantaged. We were then able to adjust our policies. So that's really important. Nationally, in the MORE Act findings, 4% of business owners in the cannabis industry are Black. And that's taking into account, all of our equity program efforts so far. So it's pretty clear that nothing that we're doing has worked. And so we should stay at the same level or do more.
So, I can just add specifically, Professor Berman, were you asking about data on impact of legalization, or?
Really all of the above. And one of the questions that I especially having the joy of working with Shalene this last year is, do Ohio General Assembly members want to hear Massachusetts data? Or I've certainly heard in a variety of other conversations about criminal justice reform, if you say this is how California does it, that'll be the way in which they say, well, we don't want to do that because look at what's going on in California. And so I'm curious, both, it's just on the substantive specifics, what you think, legislators and others care about, but even more broadly, kind of, where does data fit into this conversation as a reform effort, builds, and as particularly people in the audience may think about how they can communicate effectively to representatives, what are the issues that seem to be of biggest concern?
Yeah, so great question. Thanks for the clarification. Practically speaking, Ohio is more like that 25th, 30th, 40th state to do something typically, rather than one of the first. And that's not necessarily a bad thing, right? So we can look at what has worked.
What's going on in California. And so I'm curious, both, it's just on the substantive specifics, what you think, legislators and others care about, but even more broadly, kind of, where does data fit into this conversation as a reform effort, builds, and as particularly people in the audience may think about how they can communicate effectively to representatives, what are the issues that seem to be of biggest concern?
Yeah, so great question. Thanks for the clarification. Practically speaking, Ohio is more like that 25th, 30th, 40th state to do something typically, rather than one of the first. And that's not necessarily a bad thing, right? So we can look at what has worked and what hasn't worked in different states. As Thomas mentioned earlier, taking best practices from those states and then looking at the implications of legalization in those states and seeing data. And one thing that does come up is traffic fatalities, traffic deaths. There's mixed results from different studies. You can find some that say there's been negligible impact, some that say there has been a tiny increase because of that. The other thing, practically speaking, from a political perspective is, Ohio is not going to, move forward necessarily on something after California, and New York do it. But after that state up north, right, that I mentioned earlier, moves forward. Pennsylvania, which took a step forward, has a more robust and advanced medical program than we do. Louisiana is moving forward with decriminalization. So once you see a better, I'd say, our Midwestern peers and states with sort of a similar political makeup that we have, or states that we just like to be better than, in the case of that state up north, then we have more compelling reasons to move forward on from a legislative perspective. But again, we'll look at the impact. Nothing's perfect. No policy is perfect. But by waiting and seeing the real world implications of legalization, we can figure out what policies are resulting in the max impact for the minimum cost ultimately nationwide.
Wonderful, thank you. That was very helpful, and I know you have to go, so I just want to be sure to thank you and be grateful for your participation, and encourage you to reach out to our center and others to continue to let us know what we can do to help to advance a thoughtful legislative conversation. To that end, Tom, I'm gonna loop you back. Oh, sure, please do. Go ahead.
On the data side, please read that article, because Pew shows 40% of drug arrests were for possession of marijuana, right? Possession or sale. 92% of those were simply for possession of.
I just want to be sure to thank you and be grateful for your participation, and encourage you to reach out to our center and others to continue to let us know what we can do to help to advance a thoughtful legislative conversation. To that end, Tom, I'm gonna loop you back. Oh, sure, please do. Go ahead.
On the data side, please read that article, because Pew shows 40% of drug arrests were for possession of marijuana, right? Possession or sale. 92% of those were simply for possession of low-level amounts of marijuana. This is a massive, massive incursion and injustice. By the way, it's not great for law enforcement to be focusing so many resources on nonviolent, low-level possession. So when we look at the impacts, we can also look at what legalization would do from that justice perspective, and we have really good data on that. So I just wanted to make sure we got that out there.
Very much appreciate that, Representative Weinstein. Is singing my song, as it were, as a criminal justice reform guy, and so I really appreciate that. And maybe I'll turn to Tom then and poke you a little, because I do think some people notice, though you spoke to your eagerness to have, I guess, the study commission or the tax funding go into kind of follow up on the expungement or related type of remedial work, but that's not directly built into the initiative. So maybe talk a little bit about that choice in drawing up the initiative. And then I also guess I want to hear, you mentioned the tax revenue and where that's going to go more broadly. I assume that's going to be a selling point to voters if we're at the point where this is being considered on the ballot. But I'm curious your own take on this sort of data and advancement question. Obviously, for the 4 months it'll be in front of the General Assembly, that's a time to have your group and others, lobby them with information. But just sort of curious about how you look into the political landscape and what you think could move the needle in terms of research or focal points for advocacy.
Sure. Thanks, Professor. When you have the types of campaign efforts like the one that we're involved in, we are limited by something that's called the single subject rule, which means our initiative has to be a single subject. So every new item that gets added to an initiative proposal, whether it's a constitutional amendment or an initiated statute proposal, you run the risk that the Ohio Ballot Board is going to split that effort into two separate questions at the ballot box, and that increases and doubles the number of signatures that a campaign needs to gather, and makes it much more difficult to ultimately get something before the voters. So as the coalition kind of looked at what language we could add or how we could draft the proposal, that was sort of really top of mind. And ultimately, we felt like this was the most we could do as part of an initiated statute proposal, was to make sure there was a framework to study and fund these reforms so that they were front and center after those studies were conducted. I think it would be great if we had more direct social equity or more direct action on social equity from the legislature, but we're limited as a campaign as to what we can include within our own proposal. But again, I think we do a whole lot to advance social equity within our proposal. You know, hundreds of millions of dollars directly to social equity causes that would not exist otherwise. But you know, again, I think it would be great to have more robust efforts or more robust action from the legislature on things like expungements, you know, automatic expungements, for instance. That would be a great thing, but not really something that we could include as part of our proposal due to that single subject rule. First, I don't know if that answered your question, or if you had another follow-up that you'd like.
No, that is what my understanding of why there wasn't more packed in there, and there's already lots packed in there for sure, so I understand that. The follow-up was about sort of the data point, or, you know, kind of what you think is going to be important in your campaign's, you know, sort of efforts, both, you know, whether that's about trying to convince the legislature to adopt during that 4-month window when it's in front of them, or what you think are going to be sort of key advocacy points to the general public. I assume you have plans to run campaigns and commercials and, you know, do all that comes with every election cycle. But I don't know if you're, you know, zeroing in. You had mentioned, and we're grateful that you did, the student research about tax revenue. That always is an important point, I think, when you're speaking about these matters to the voters. But I'm wondering what else, if you're comfortable, you know, talking through, you think are the kind of key conversation points going forward over the next year, assuming, as I assume you're planning around the possibility that this ends up on the ballot.
Well, I mean, to be clear, we're not really focusing at all about a ballot campaign. Right now, we are laser focused as a coalition on engagement with the legislature, because we think and are confident that once our proposal is firmly within the General Assembly's hands and it's something that they have to deal with, that we can move the needle. And maybe some robust and vigorous debates within the legislature on the topic of marijuana reform. But as Mary Jane mentioned, you know, and in my experience, it seems like Republicans are more favorable on this issue than we might give Republicans credit for. Speaking as a Republican, you know, it's not terribly surprising to me, because again, it comes down to, this is an inevitability, right? I think most people recognize that. And the question is, who's going to make the decision? Is it going to be Congress, the Biden administration, or the General Assembly? And how do we do it responsibly? And we think our proposal does that. And one more point on the topic of criminal justice reform. And again, just to be clear, ending marijuana prohibition is itself an enormous step toward criminal justice reform. You know, Representative Weinstein's exactly right. If we could eliminate 4 out of 10 arrests and prosecutions overnight, that would be a great thing. And we think when you couple that with some of these direct investments into disproportionately impacted communities, we think that's a great selling point on the cause of social equity. And we think marijuana reform generally is popular among Ohioans. So candidly, it makes my job as spokesperson